Greetings, everyone. This is Professor McKenzie. Today we're going to be looking at Chapter 14, which is entitled Third-Party Rights. The focus of this chapter is we're trying to understand when a contract has been created where the parties that created it, the parties on each side that created this agreement, actually intends to have the agreement benefit someone usually not present at the time the contract was created. That's what we're talking about here with third-party contracts. And so we're going to go through some examples where the courts have found that these are instances of third-party contracts and instances where this is not. So a big focus that we're going to try and determine is, does someone have the expectation of third-party rights? So are they identified like as an intended beneficiary of the agreement, or are they considered what is labeled as incidental beneficiaries? Intended beneficiaries have rights. Incidental beneficiaries do not, as we'll discuss. Anyway, the learning objectives for this chapter. First, we're going to discuss how an assignment of a contract right is made and how it operates. We'll talk about delegation of duties in contracts, and then under what circumstances a person not a party to a contract can seek enforcement of that contract. So that's the overall kind of big picture as we go through this chapter. So as I mentioned, third-party beneficiary contracts, if you have a contract that has clear intent that its purpose is to benefit someone else, and they may be present at the time of the creation of this agreement or not, then those persons are referred to as intended third-party beneficiaries. The third-party beneficiary, the key thing to know is that they are subject to any and all limitations or restrictions found in the contract. That's the key thing to always know. They don't have additional rights that that they think they might have. The only rights that they have are what are included in that contract. It doesn't matter if they were present or not at the time of its drafting. They are constrained by those terms in the agreement. So a couple of examples of third-party beneficiaries. There are situations where you have what are called creditor beneficiaries. And so this usually is the focus when the contract is, let's say, to purchase a business. So when you buy a business in its entirety, you're buying everything, its assets as well as its liabilities. If you're buying just merely business assets, then obviously we're not discussing third-party beneficiaries then. But if you're buying a company, you're buying all of its, assets, which could be, accounts receivable, as well as its liabilities, accounts payable at that point. If we're talking about another category of intended third-party beneficiaries, we're looking at what's called donee beneficiaries, and this is where the promisee's purpose in making the contract is to make some kind of a gift or payment to some third party. The best example there, and the one that is most commonly referred to, are life insurance policies. And so, whether you get it through your employer or if you seek on your own, like in private insurance markets and exchanges, a life insurance policy, you enter into that and then you designate whoever is your beneficiary, that person, upon death, then they will receive whatever those proceeds are as per the agreement. Again, always remember that they are bound by any limitations. So that's going to be a key thing to understand when we talk about life insurance policies. So here's just a visual kind of like summary of some of these third-party beneficiary contracts. So, when one company buys another and it's in its entirety, not just an asset, but you buy everything, there's going to usually be third-party beneficiary contracts that get triggered. The example where maybe a parent goes to a dealership to purchase a vehicle for, let's say, a child, that's in college or high school, doesn't matter, adult, then that's a third-party contract. And then obviously, what I just mentioned a few moments ago about the life insurance policy. All of those are examples where you have a third-party beneficiary contract and you have identified intended beneficiaries for each of those agreements. So third-party contracts, it is possible for them to lose rights in the original contract in a couple of different situations. First, if there is some termination by operation of law, or if the contract reserves the right to change beneficiaries and such change is made. Um, to give you a couple of examples here, let's say both of them involve life insurance policies, because I think that's what most people have a familiarity with. So if I get a private, aftermarket life insurance policy through some insurance company, and let's say, I'm making, monthly payments. If for some reason I cease making those monthly payments, then by operation of law and per the agreement's going to be canceled. That's usually what's, part of the requirement for any kind of policy is that you have to keep up with the required payments as per the agreement. The other situation is, for life insurance, let's say that I change who the designated beneficiary is. That is my right as the person who created that contract. There's been numerous cases where this issue has been litigated, but the stories that I've kind of encountered are where, let's say, you graduate college, you get a job, and let's say you meet someone and you decide to get married. So you're still in your 20s. And you designate your spouse as your beneficiary for your life insurance policy through work, which that's fine. That's you can put anybody, but you listed your spouse. Years go by, and let's say you're with the same employer. Let's say it's 10 years that goes by. Let's say 5 years, into your job, you get divorced, and then a year or two later you get remarried, and then you die. If you never updated your life insurance policy, your ex-spouse is going to be the one that will receive the proceeds. The third-party intended beneficiary contract of a life insurance policy operates outside the purview of wills. So they are two completely different things. And, you may say in your will, I want everything to go to my current spouse. That's fine. But, again, these third-party contracts have no part of the will. They're not an asset that you own because they don't come into being until you already have passed. So it's always important to remember that you update your life insurance policy to reflect changes in your status. So that's critical to make sure that happens. Anyway, in addition, if third parties sue because let's say there was some sort of compliance or non-performance as per the agreement, the rights that the beneficiary has, those rights are all contained in the agreement, and it doesn't matter that they weren't there when the contract was created. So again, like with the life insurance policy, if you have one through your employer, and you pass, most employers know when you no longer are alive. They'll figure that out, and then they'll notify the insurance company, and then they pay out as per the beneficiary listed. If you have a private, like aftermarket life insurance policy, they are not going to know that you passed necessarily unless they get notification. So a lot of policies do have a time restriction so that you have to give them notice within, it could be 180 days, could be, more or less depending on the policy. And if you go past that window, then you lose the opportunity to claim the benefits then. There have been many cases, again, where there's been a beneficiary and they didn't know they were a beneficiary until a year or two later, and then when they approach the insurance company doesn't pay out because you exceeded the time limit required for the reporting of the death. So it's very, very critical, even though it's an uncomfortable conversation, if you do have someone designated as a beneficiary, make sure they know that fact. And also they need to know what they need to do when that event occurs, who do they need to contact, where is a copy of the policy, so that they can properly process and get the benefits of the agreement that you created for them. So that's really essential to do. Incidental beneficiaries, unlike intended beneficiaries, they benefit from the performance of a contract, but they were never contemplated or guaranteed as being a beneficiary. They were just kind of fortunate to reap the benefits of that contract and its existence for whatever time that they were able to receive those benefits. Generally, if you're an incidental beneficiary, you do not have legal standing to sue if the contract ceases to exist or some event occurs where you no longer receive those benefits. You have nothing to sue over at that point. Courts usually consider, would a reasonable person believe that they were either an intended beneficiary or an incidental. If they're incidental, then again, they lack the standing at that point. I give the example sometimes. This is a non-life insurance policy example. Let's say you have a shopping, kind of like a strip center, so you have like, maybe a row of businesses. There might be 10 businesses in the shopping center. And let's say that there's an anchor, maybe grocery store, maybe it's, let's say it's Publix or Aldi. And all the other small businesses are there just because they're there. Maybe it's it could be a Hallmark store, it could be a restaurant, it could be, I don't know, comic book store, whatever it is, insurance company. And so, their lease for their retail location in that strip center could just be for that business. It's not necessarily tied to the fact that Publix or, Aldi is there. So if the anchor store moves and moves across the street or down the road or goes out of business or whatever, if you're one of those smaller businesses, you were an incidental beneficiary at that point. And so the fact that you got maybe extra business because of that anchor that was there in that strip center, that's great. You were able to get extra business. But the fact that that anchor is now gone, you can't just say, well, I'm breaking my lease because the anchor store is no longer there. You would actually have to have in your lease that, this lease is only enforceable as long as this anchor is there. And if the landlord agrees to that, then that's fine. Then you would be considered an intended beneficiary. But if your lease is just a lease for space, in this strip center, that's independent of whatever businesses are around you or not around you. And so that is an obligation that you would have. And, the fact that, the anchor is gone, you can't claim that you have some right to sue them at that point because you were never an intended beneficiary. You were just incidental at that point. This slide is a great kind of listing of, what would be, considered intended versus incidental. So I won't read all this to you, but it's a good reference as you try and kind of process the information and the content in this chapter. Just remember, overall, with intended, it's very clear when the contract was created that they were contemplated and that they were, identified either by name or, by some sort of label, that this is who I want to benefit because of this contract. The incidental beneficiaries, again, it's from economics. There's this term called externalities. Sometimes there's an overflow where you receive a benefit, and again, you weren't intended to receive this benefit, but the fact that you got it, well, it's great that you got it while you could or while you can, but once it's gone, it's just gone then at that point. In terms of legal action, this is just a visual way to kind of process this. If you're a creditor beneficiary, you can take legal action against the person who made the contract on their behalf, or against whoever is supposed to be the performer of the contract. So you've got some options there. If we're talking about the donee beneficiary situation, so like with life insurance policies, usually, your primary focus is that you would take legal action against the performer of the contract. If you're incidental, you're kind of just out in the rain. You have no real recourse at that point. Again, you were lucky to get while you could whatever those benefits were. If we're talking about an assignment is a transfer of a right. And so the labels, and I'll kind of go through the labels in more detail in just a second, but if you're the assigner, you're the one that's transferring some right to another party, and that other party is labeled the assignee. So that's just some verbiage for you to kind of understand. Normally, there's no formal requirements with an assignment other than you state, whether it's verbal or in writing, and again, I always prefer in writing, that you intend to transfer. And that's usually will suffice. Again, if you're assigning something, all you are assigning is what that underlying agreement is, and the rights, the obligations flow to the assignee from the assignor. That's all that's expected at this point. You don't get any additional rights. You can't change or modify things. You just have to take it as is. Assignments can either be gratuitous, which means as a gift, or it can be for consideration. So let me give you, I give two examples. Let's say that you loan it doesn't matter. It could be friend, business, stranger, whatever. You loan somebody some money, and essentially you have them sign a promissory note. So let's say you loan someone $5,000, and the agreement is that in 1 year they'll pay you back. And maybe whatever plus interest if you do interest, whatever. You loan the money today, they sign it, it's properly executed, so you have a promissory note. So this person knows, 1 year from today, or before, they have to pay you $5,000. Okay, fine. Let's say, 6 months goes by and, you realize, I don't really need this money. I want to give this to a charity, or I want to give it to another family member, friend, whatever, it doesn't matter. And what you're intending is that when this person pays the $5,000 back, instead of paying, they're going to pay whoever you've given or assigned the promissory note to. So, and in this example, it's just a gift, and so you don't have to buy it or sell it or anything like that. The key thing, though, is that you do have to notify the party who has to pay, and you have to let them know, okay, when you do pay within a year, pay this new party, you don't have to pay me anymore. And they don't need to know why. There's no explanation. It's just you're directing them. Nothing changes except who they're paying it back to. That's it. The other example that I'm thinking of, and this is where an assignment is made and it's for consideration. So if any of you have ever purchased a home, and when you think of like the mortgage industry, there are primary lenders and then there are secondary lenders. A primary lender is usually the one that will help get you at closing approved, and they will take care of, transferring whatever the funds are to the seller so that you can get your home. And then at some point, soon after the closing, you begin making your monthly payments to pay back the finance company, the mortgage handler that, basically, put the money in advance to pay for your home. Usually the primary lender does not want to be your primary lender for 20 to 30 years, So what they'll do is they will discount your mortgage and sell it to a secondary handler. And then that secondary party, or maybe even subsequent parties, even after the second one, they will handle your mortgage for the life of it. And so because your primary lender, they may not want the income stream for 30 years on a $500,000 mortgage. They would rather discount it, whatever percentage points, and then get the bulk of their money back immediately. And then whoever bought for consideration that mortgage, then they will notify you that, hey, going forward, make your payments to us, not the original lender that you dealt with. Again, the terms of the contract don't change. Your principal is the same, your interest rate is the same, your monthly payment is the same. Nothing changes except who you're directing payment to. But again, what's key is that you have to notify the debtor, the person who has to pay. You have to notify them so that they know who the correct party is to pay. The significance of notification is kind of detailed here in this example. So what I have here is it's a flow chart, and so you have Bob, who's an obligor. That means he's the one who owes money to Mary. Mary is the obligee. And so Mary knows that Bob owes her money, and she decides one day that she's going to assign the obligation that Bob owes. She's going to assign that to Todd. Doesn't matter who Todd is. Todd could be a friend, a neighbor, family member, a stranger. Doesn't matter. And so she assigns this. So Mary, in this capacity, is the assignor. Todd is the assignee. So again, you kind of see the dynamic here. The result of this assignment is that when Bob pays, we need to make sure he pays the correct person, which now is Todd. It's no longer Mary. His obligation hasn't changed. The amount hasn't changed. The interest rate hasn't changed. Nothing has changed. So he just has to pay a different person. That's it. So let's say that Bob, when it comes time to pay, he pays Mary, by accident, and he doesn't pay Todd. Well, okay, now we have a problem because, Todd he's going to be contacting Bob, and he's going to say, where's my money? You owe me this money. And Bob, what we're going to have to figure out is, was he given notice or not of the assignment, because we have to notify him. So in this flow chart, where you see in the center, in that blue box, it says, has the obligor, Bob, been informed of the assignment and been notified to pay the assignee, which is Todd? If he has been notified, so let's say, maybe Mary and Todd both contacted Bob and said, look, when you pay, make sure you pay Todd. If he erroneously paid Mary, he still owes Todd at this point because he was notified. What he's going to have to do is get with Mary and say, look, I need my money back because I shouldn't have paid you. And so either, that may end up in litigation, or Mary just say, okay, fine, I realize you made a mistake there, and maybe Mary didn't catch it. But Bob still has to pay Todd at this point. If you see in the red circle there where it says no, if Bob was not notified, the fact that he paid Mary, he has settled his obligation then. If Todd and Mary cannot prove that they notified him. And what happens is Todd then would have to go back to Mary and say, look, Bob paid you and we know he shouldn't have, so you got to pay me now. So, you see what results here depending on if proper notice was given or not. If proper notice was given and Bob paid it correctly, we have no issue. If proper notice was given and Bob paid the wrong party, Bob still owes the correct party. If Bob was not given notification and Bob pays, the original party that's incorrect now, his obligation is satisfied. So again, I don't know if this helps, but I know sometimes students can be kind of visual, and this is just a more of a visual way to kind of go through the steps to trying to discern, if an assignment has been transferred, the importance of notification for the person who is obligated to perform. If we're talking about any type of continuing liability, the assignor remains liable unless there is some kind of agreement to the contrary. Usually if you're the assignee, you don't have any liability because you're the one that just is the receiving party. Whatever the benefit is that's being conferred, you just have to be there to receive the benefit. So normally there isn't any kind of liability on the assignee at this point. If a contract involves, let's say, delegation of duties. So, sometimes contracts, may involve where it's like, okay, a party has to perform some specific duty. And, let's say this party wants to delegate it and transfer the obligation to perform to somebody else. Usually what we look at is the person who has to originally perform, were they contemplated as someone who has some kind of special expertise, skill, judgment that necessitates that only they can be the ones that can perform? They can't, subcontract it or transfer that obligation to perform to somebody else. So the example I give, LeBron James, if, let's say if through some kind of bizarre happenstance, you contract for basketball lessons from LeBron James. So, whether it's a charity thing or, whatever, it's, you have this agreement, he's going to show up and he's going to give you a series of lessons on playing basketball. So let's say you show up and he's not there, but maybe his nephew is, and one, I don't know if he has a nephew, but let's say he does. The nephew may be a great basketball player, but, no offense, you wanted lessons from LeBron James. That's who you contracted with. So that's, that obligation still is outstanding. LeBron James cannot transfer that unless somehow, he seeks permission from you to transfer it, and for whatever reason you're okay with it, then he can transfer it. But without that authorization, he still is obligated. Change the facts a little bit. Let's say you have an office cleaning business and you have a variety of accounts where you come in like at the end of the day and you perform office cleaning services. And let's say that, you decide you don't want to office clean anymore, so you want to basically subcontract or maybe assign the right to these contracts to another office cleaning service. If the agreement doesn't say that you can't do that, then normally that's going to be fine then. So you're going to want to notify, obviously, your accounts so that they know who the correct party is to pay. But, to clean offices doesn't usually require any kind of special skill or judgment or element of, qualifications other than it's just hard work. So in that instance, you could delegate your duties under the contract to another party. And again, it could be an assignment either for or with or without, I should say, consideration at that point. So that's just, again, how that would kind of play out if you're trying to delegate the performance of some obligation other than just simple payment of money. Other contractual rights that cannot be assigned. So, again, if you have some element where it involves, skill or judgment. So I call that like the LeBron James rule. Rights, whose assignment would increase the obligor's risk or duties. Obviously, that can't be assigned. If it's prohibited in the agreement or if it's prohibited by law or public policy. The prohibited by contract, I've seen that come up in the context of apartment leases. And so, for those of you that are living in an apartment, if you have read through your lease, you might have recalled this, or if not, maybe refer to it. But if you decide you want to leave early from your lease, technically in the terms of the lease are that you are obligated for the full performance. So, whatever the duration is, if it's a 6, 9 month, year lease, whatever it is, you're required to keep making payments until they're able to fill that vacancy if you decide to leave early. So if they can fill that vacancy early, then you're released from your obligation. Otherwise, you got to keep paying for that apartment or whatever the dwelling is that you're renting. If you're trying to have someone step in to take your place, so maybe you're moving, but you have a friend that would love to move into your residence that you're renting. A lot of times, most contracts do require that you have to notify and then you have to seek approval before it's authorized. And the main reason, if you're the landlord or if you're the owner of the structure, you want to just pre-approve, to make sure whoever is coming in is going to be a reliable tenant, in whatever capacity. And so as long as they pass the approval process, then normally you get released and they step into your shoes. And the owner or the landlord, they get their income stream as per whatever the original agreement was. But that's an example where you can insert that into any contract and say, look, if you want to assign or delegate this, you have to get it prior approval first. So anyway, I hope this helps understanding a little bit better some of the different facets of contracts by looking at the third-party rights to contractual agreements. Remember, big picture, if we're talking about intended versus incidental beneficiaries have no standing to sue if they no longer receive the benefits of the contract. Intended beneficiaries do have standing, but they are limited to the terms of the agreement as they were drafted, even though they weren't present when the agreement was created. So you make sure they know what their rights are and obligations under the contract. And then when we're talking about assignments, if an assignment occurs, it can either be gratuitous, meaning as a gift, or it can be for consideration, either way. But you have to notify the other party to the original agreement that an assignment has occurred. Their obligation doesn't change, just who they have to provide performance to at that point. Have a wonderful rest of your day, and I will be chatting with you all again in our next chapter. Thank you.